Things you need to know. You need to know about the Clash. It won't come up in the exam, but you should definitely know about the Clash. What you also need to know about is judicial neutrality, independence, judiciary and the citizen, judiciary and the state. So let's make a start on that. This presentation is going to be all about neutrality. The next one will be all about independence. After that, we get on to the citizen and the state. That's where it gets a bit more tricky, but we can worry about that later. Anyway, we'll also worry about the Clash later. Thank you very much, lads. So let's push on. What are we looking at here? Well, we're looking at what the judiciary does in the UK. And the first thing that they do is they observe and enforce the rule of law. Now, you'll remember what the rule of law is. All laws apply to all people at all times. We'll talk about that again in a little second. They also observe and enforce the rules of natural justice. That is, that law and its administration should be fair. They also uphold the will of Parliament. Parliament's will is the law. And the job of the courts is to establish exactly what that law means, to identify where it has been breached, and to decide what should happen as a consequence of a breach in the law, that is, sentencing and punishment and so on. They also need to identify where the state exceeds its authority. That is the principle of judicial review, and you'll be spending an awful lot of time on that. And it is tricky. I'm not going to pretend that it's not, but it's also fun. If you're one of those kids who loved rules when you were younger, or perhaps still love them now, and you're always making up rules and getting upset when people broke them, you're going to love the law. It's all about rules. It's all about that particular legal game. So let's push on with some definitions. The rule of law, all laws apply to all people all in the same time. So we can drill into that, and we can say that means that everybody is equal before the law, the equality before the law, and that at all times due process must be observed. That is, the wheels of law justice must be allowed to turn and turn to their complete turn completely to the end, if you will. There's no shortcuts. There's no skipping anything. Everybody has to go through the whole process. Natural justice is the idea that law and its application should be fair. We can look at various aspects of that. I'm going to identify two. Everyone is entitled to a free trial, a free and a fair trial, and generally it's preferable that the guilty goes free than that the innocent is punished. Those are two principles of natural justice. There are many, many more, but the key idea there is that law and its application has to be fair. The two we're going to focus on next are perhaps critical: judicial neutrality. That is the idea that the judiciary should be free of bias. It shouldn't be political. It shouldn't be politicized in any way. That means that any outcome should be entirely independent of the nature or prejudices of the agents. And judicial independence, which means that the law should be free to operate from any outside bias. There should be no outside influence working on the law, making it move in a particular direction. So, natural justice, just before we push on any further, the courts have to step in. Matrix Churchill is one example where this company, Matrix Churchill, was accused of shipping banned substances, banned material, with centrifuges or pipes or something to Iraq. It turned out that the MI5 knew about this, or maybe didn't know about it. They said one thing, somebody else said everything else, and it was evident that there was no way it was going to get. There was no way a free trial could be guaranteed. And so eventually the judge said, this is rubbish, and pulled the plug on it. The one that we're going to look at in a little more detail is the Jubilee line fraud trial. This was in 2002 to 5. Basically what happened was we'd had this extension of the Jubilee line. It used to stop at Green Park, if I remember correctly. Of course, now it goes all the way on to Greenwich and beyond. The problem was that this trial lasted 3 years. It started in 2002. It was still going in 2005. The cost is kind of moot. What is not moot is these 12 jurors. Now, if you called up for jury service, your name is plucked off the electoral register. You're told to turn up at a court at a certain time. They'll say, well, we're probably going to have you for a week, maybe 2. Well, these guys were there for 3 years. In the course of that, their lives went basically on hold. People lost their jobs, marriages started to collapse. After a while, the judge said, we can't run this. There's no way we can have a fair trial here. Did these guys defraud the government? Who knows? They certainly seem to have an awful lot of money. But did these guys defraud the government? We don't know. We will never know, because the judge said this has been going on too long. We cannot have a fair trial here, And so, based on the principle that it is better that the guilty go free than that the innocent are punished, he pulled the plug on the case. These guys walked out of court, and the jurors went back to whatever wreckage was left of their lives. So that's the Jubilee line fraud trial. After that, actually, the rules pertaining to complicated fraud trials were changed. They're no longer heard by a jury, which is probably too late for these guys, and fortunately too late for these 7 businessmen. Anyway, that is natural justice. I don't want to spend too much time talking about that. We can address it in class. The main idea, it has to be fair. Now, Constitutional Reform Act is one of the most important things that important bits of legislation that we've had for a long, long time. The Constitutional Reform Act was an attempt to establish the independence and the neutrality of the judges, and it did that in a number of ways. Judicial independence, it created a statutory duty on government ministers and indeed everybody else to uphold the independence of the judiciary. You are officially, specifically barred from trying to influence a judicial decision. At the same time, they reformed they reformed the role of the Lord Chancellor. Now, the Lord Chancellor was a politician. He was also head of the courts of England and Wales. Now, you can't have a politician who is also head of the courts. That's the sort of thing that happens in banana republics. And eventually they said, well, we have to do something about this. You can't have the courts answering to a politician. That just fundamentally undermines the neutrality and the independence of the judges. And so they transferred his functions to the President of the Courts of England and Wales, who assumed responsibility for training, guidance, and the deployment of judges. He's also now responsible for representing the views of the judiciary to Parliament and government, but that's kind of a rounding error. The main point is this was an attempt to establish some sort of divide between the political world and the judicial world. And up to that point, the Lord Chancellor certainly had been jumping from one to the other with an alacrity and an ease that really upset an awful lot of people. So the Constitutional Reform Act about independence and neutrality. The Supreme Court was established, to be honest, relative to the other two, it's a bit of a rounding error. It's nice. I mean, it's nice that the judges have got their own place to work. Certainly, it establishes a degree of separation from the House of Lords, which was previously the Court of Final Appeal. But now, the Supreme Court there, it's a nice building. But what's more important is that the judicial appointments are now officially independent of government. Previously, they were steered by the Lord Chancellor and the Prime Minister. It was all a bit of a mess. So the Constitutional Reform Act has done an awful lot to establish a clear sense of independence and neutrality in the British judiciary. So let's talk a little bit more about neutrality. We'll start just by looking at this particular photo. Now, no child protection issues involved. These are my kids. Well, they're not my kids. They're all my family. But the question is, which of these child has the nicest smile? Now, you might very well say, well, it's obvious. Of course, it's this one here. He's got a lovely smile. And you'd be absolutely right, because he has got the nicest smile because he's my son. But the question is, am I qualified to judge that? Am I neutral? Can you trust my judgment? If you knew that that was my son, would that mean that my judgment was somehow compromised? And it should be, because I'm not neutral. I'm not neutral in this particular exercise. Now, these are his cousins. That's Nick, and he's a super chap, and that's Alex, and he's a lovely lad, and that's Lillian, and she's absolutely wonderful. But that's Oscar, and I'm not neutral in this, and as a result, I am not able to judge. I have to recuse myself from this particular exercise and let somebody else judge. What that means is that I don't move in a straight line. I am biased, just like these cricket balls, which are swinging in particular directions because of the shiny side and the dull side. There is bias in this particular system, and we can't have bias in our courts. How do we do that? As I said, it's all about establishing a degree of separation from the political system. So in terms of appointment, the appointments are made on merit, not on politics. And the operations, we operate according to the rule of law, natural justice, not the dictates of political masters. There's no other agenda or influence at work. Critical to this is this idea of judicial appointments. Judicial appointments are made by an independent commission, which was created by the CRA. Previously, they were made by the Lord Chancellor. Again, he was a politician, and that made things a little suspect. And all appointments on the basis of merit. So judicial neutrality, how do we achieve judicial neutrality? Because we appoint our judges because they are good, not because they have a particular opinion. We can contrast that with the United States. We'll do that in class. Well, there you have an overtly political process, and it's very, very different. There are certain problems with neutrality, specifically demographics. The overwhelming majority of judges, especially senior ones, are pale, male, and frail. That doesn't mean they're necessarily biased, but it makes it kind of awkward. It does mean perhaps they're drawn from a narrow section of the community, and they have a certain set of principles or prejudices that may disadvantage other members of the community. Specifically, it's said that there's a small c conservative bias. We can talk about Archer. You can read that in your own time because I'm running out of time. What I really want to go to is really a couple of points here. This is a point on gender. As you can see, them females profoundly underrepresented, and the same here with ethnicity. Gender and ethnicity certainly issues in terms of neutrality. Here's an example of neutrality in principle and practice. In 1998, Lord Augusto Pinochet was facing extradition treaty hearings. The law lords, this was when they were still in the House of Lords, they decided he could be extradited. The problem was one of those judges, Lord Hoffman, had long-standing ties with Amnesty International. He didn't declare these, and so he should have said at that point, look, I'm not fit to judge this because I have ties with Amnesty International. And Amnesty International have been chasing Pinochet for a long, long time. He should have said, no, I can't judge this. It's not because I am biased, it's because people might accuse me of being biased. But he didn't do that, as a result of which the trial collapsed. One more, which is a personal favourite of mine. Sheri Booth handed down a reduced sentence to somebody because he was religious. Now, the National Secular Society went berserk about this. You're going to have to read this in your own time again because I'm running out of time. The point was that another judge may have given a different outcome, because if you had a non-religious judge, would he have seen things the same way? Mrs. Booth got a really big rap across the knuckles, indeed, from the senior judiciary on that, and that was that. So, judicial neutrality, the idea that you should leave your prejudices at the door. It doesn't matter how you feel about religion. It doesn't matter how you feel about football teams. It doesn't matter how you may feel about people with a particular hair color. You should not let that sort of bias intrude on your decision. The only thing that should affect your decision are the principles of natural justice and the rule of law. Anything else has to be left to the side. Now, I've gone through that at a tremendous rate. There's going to be lots and lots of questions. I look forward to fielding them. But in the meantime, enjoy that. We'll talk about it in class.